Good afternoon to all of you who chose to attend our, I don't know which number of our IP updates we are now, in relation to a subject matter which is still, despite all the years, still very relevant and actual, which is the question of the liability regime of IP holders, patentees in particular, who obtain provisional measures which subsequently disappear from the legal order. The question still arises within that context, to what extent, if and to what extent, an IP holder can be held responsible for the damage, the costs incurred by the alleged infringer. I'm happy to present this IP update together with my colleague Kirian Clayer. We will act as always, and you have the possibility to ask questions. We will try to be ready in time so that there is time at the end of the session to answer any question which would have been raised. Now, as for the outline of our presentation, the reason for us to organize this session was a recent decision of the Court of Appeal in a litigation involving Novartis and Mylan, which applied the concept of fault liability as opposed to strict liability within this context. And we, of course, intend to discuss that decision, but in order to be able to explain the reasons for that decision, I think it's important to start with the beginning. So I will give you an overview of the relevant legal provisions at the Belgian level. And for those of you, of course, who are not Belgian lawyers, this might perhaps be somewhat less interesting, although I imagine that we have similar provisions in other countries. I will discuss the case law as it had evolved in Belgium before the landmark decision of the Court of Justice in Bayer. Subsequently, Kirian will discuss that decision, what has been decided, and apply it to the situation on which the Brussels Court of Appeal had to decide in the Novartis case. And I will end this session with a short discussion of the Iliad referral, which is pending before the Court of Justice, and the questions which will arise within that context. So allow me to proceed with, first of all, of course, the background of our Belgian case. We, since always, had a number of general provisions, which, of course, are relevant within this context. The general principle of tort liability, Article 1382 of the old Belgian Civil Code, still applicable, providing for the principle of fault liability, and which of course also applies to procedural parties. One can indeed proceed before the court in a faulty manner. One can indeed commit a fault by enforcing a certain court decision. Within that context, we also have the general rule of Article 1398, which provides that if a decision is not final, the enforcement thereof, any court decision, the enforcement thereof shall be at the risk of the enforcing party. And contrary, of course, to the tort liability rule, this is a rule providing for strict objective liability for a party which enforces a court decision which is subsequently overturned, be it in appeal or in opposition. Now, since the enforcement directive, we have obviously a number of special provisions applying to the enforcement of IP rights. Today we will mainly discuss Article 9.7 of the Directive on Provisional Measures, which provides for the possibility, the authority of the judicial authorities to order the IP holder to provide appropriate compensation for any injury, so any damage caused by the measures, when the relevant provisional measures, and these are three situations, are revoked following opposition or appeal within our context, or lapse due to any act or omission, and we also have that provision applicable in Belgium. If you do not follow up, in particular, your PI decision with proceedings on the merits, respectively also within the CSI context. Our third hypothesis, if it is subsequently found, and that is of course the most interesting one, that there has been no threat of infringement. We find the same provision, Article 9.7 being, by the way, also a copy of Article 50, Paragraph 7 of the TRIPS agreement, so there is nothing new in that respect. But we find the same provision in Article 7.4 in respect of measures to preserve evidence, and within the Belgian context, obviously this will become relevant when a saisie contrefaçon order is being enforced. How have these provisions been implemented in Belgium? I think it's important to note the implementation is nearly totally literal, with the exception that in respect of provisional measures, PIs, Article 1369 ter does not use the wording of the enforcement directive, but only provides that the court can order the applicant to provide appropriate compensation. It has been held sometimes that this is an incorrect implementation of the enforcement directive. That remains to be seen. I don't think that is correct. In any instance, this provision will have to be applied by the courts in a way which is consistent with the directive and with the interpretation, as we'll see, which is given to the directive by the Court of Justice. We see, again, in respect of descriptive saisie or effective saisie measures, the same wording appear again in that context in the Belgian judicial code. As a further information, I would also like to refer to, because that will come into play in particular if revocation of the patent or the IP is decided by the competent court. Obviously, we need to refer to the principle that such revocation will have retroactive effect. That's Article 68 of the European Patent Convention. It also applies in particular to Belgian patents under Article not 9 but 11.58 of the Code of Economic Law. And there is also a provision in Article 11.58 of the Code, which strangely enough has never been applied within our context, but which could, I think, become relevant, because it is said that the retroactive effect of a revocation has no incidence on infringement decisions which are final, have acquired final authority of res judicata, and which are carried out before the revocation decision. So that could be an element which perhaps could come into play in the future, at least in the Belgian context. Now, turning to the case law, which was developed by the Belgian courts before the Bayer decision, we see a dichotomy. Let me explain it to you. On the one hand, there was, or it is generally accepted, or it was generally accepted up to now, that whenever the provisional measures were revoked or in appeal, that Article 1398 of the Judicial Code would apply. Up to now, we have not found any decision which stated otherwise. This goes back to a consistent case law of the Belgian Supreme Court, of course not only applicable in IP matters, but also in IP matters, in particular the decision of 10 September 2004 of the Cour de Cassation related to a copyright case, where it was held that indeed Article 1389 has a general scope of application, and that if the decision is revoked, overturned, it is supposed not to exist any longer. The nullification will have an ex tunc effect, a retroactive effect. And we come to a situation where it appears that the provisional measures were thus enforced or requested, depending upon the circumstance, without any legal ground. And it is held in that context that any IP holder who enforced such decision, which is subsequently overturned, is subject to a regime of strict objective liability. However, in the other case, the hypothesis which we already touched upon, where the provisional measure continues to stand because it is, for example, confirmed in degree of appeal, or it is not contested anymore, but subsequently the IP right involved, patent involved, is held to be invalid or non-infringed, then the majority of the case law, and there was no consensus in that respect, applying Article 3069 bis and Article 1369 ter, so the implementing provisions of the enforcement directive, considered that within such context the liability would be a fault liability, that one has to put oneself at the time that the measure in question was requested or enforced in order to decide whether or not that act was to be considered as a fault. And the reason which in many cases is invoked in that respect to justify this is that, of course, the PI decision, the provisional measures, continue to exist. They remain in the legal order. They are not revoked with retroactive effect, but they become unenforceable at some point. And that goes back quite some way to the Balta decision of the Supreme Court in 2005, and to the Snowfall decision, as we say, of the Brussels Court of Appeal of 2018. And also in the Novartis case, the first judge, which made a decision in first instance, which was appealed and which was recently decided by the Court of Appeal, on which Kilian will provide further comments. Also, the Commercial Court of Brussels at that time decided that Article 1382 should apply, that the regime should be one of fault liability, and it did this on the basis of a reasoning which was quite interesting. It's another way to reach the same result, deciding that, considering that at the time of enforcement of the IP, the patent involved was still on the books, was still valid and enforceable, it is not possible subsequently to decide that there was no infringement. It's a kind of literal interpretation, which again leads to the same result, meaning that a regime of fault liability should apply. But that, as I mentioned, this viewpoint of fault liability was not uniform, and there is in particular one decision of the Ghent Court of Appeal, which decided that carrying out saisie measures, which when subsequently the IP right is revoked, lead to a regime of objective liability. So it is not necessary to demonstrate that by carrying out the saisie measures, the IP holder committed any fault. So we have that dichotomy, and then we have, of course, the other situations where are not envisaged by the enforcement directive. In Belgium, we have the possibility to request PI measures or saisie measures to be withdrawn. I mean, the wording in the law is sometimes different, but basically it comes down to the fact that due to changed circumstances, the PI or the provisional measure is not maintained. And the question within that context will arise, of course, if that happens, and if subsequently, of course, you lose on the merits, what would be the regime of liability according to a applying general Belgian procedural law? It would be again a regime of fault liability, not strict liability. And probably the same conclusion could be made, although there is no case law in that respect, pre-Bayer, that equally a regime of fault liability will apply when the measures lapse due to an act of omission by the applicant, if he does not file proceedings in a timely manner, for example. Article 1398 will not apply within that context, but it is clear that possibly Article 1382 could apply, in particular in a case where the IP holder indeed fails to meet the requirement of the law and to start proceedings on the merits in a timely manner. So we had that diverging case law prior to the Bayer decision, and the question is, of course, what did the Bayer decision change to this situation? Leave the floor to Kilian to discuss this.
Thank you, Christophe, and good afternoon to all as well. I hope you can hear me well. Okay, good to hear. So let me start with explaining the CGU's Bayer decision of 2019. So it dates back already 3 years. Nonetheless, it's, I think, still relevant, as we will see, first of all, because the Brussels Court of Appeal, of course, applied the CGU's Bayer decision. And secondly, since new questions continue to being asked to the Court of Justice by national courts, which Christophe will discuss, and some national courts applying the CGU's Bayer decision differently, actually, from the position of the Brussels Court of Appeal. Now, the factual background of the Bayer decision, I've included the entire background on this slide, try to summarize it as accurately as possible. I won't go into too much of the details. I think this is actually the essence of the factual background. It's important that Bayer was actually granted a PI in 2011, July 2011, and this PI was overturned in September 2011. After September 2011, there was also a remittal back to the first instance court, and the first instance court, as you see on this slide, also eventually refused a new PI. So there's been, let's say, a rather delineated and limited time period where there was, in any event, a PI imposed on Gedeon Richter and Exceltis, the two defendants in the case, and they eventually claimed damages, one already in 2012 and the other in 2017. They claim damages after the patent has been held invalid. Now, Hungarian law, and it's a referral from the Hungarian court, so Hungarian law is important, and that was the background also. Hungarian law has no provision that is similar or identical, to our understanding at least. We're not Hungarian lawyers, but that's what we understand from the decision and from discussion with our colleagues. No similar provision to Article 9.7 of the Enforcement Directive. And instead, there is a kind of bonus pater familias assessment in respect of both the parties. Actually, Hungarian law says the defendant, and the one who has been imposed a PI based on intellectual property, will not be compensated for the loss suffered as a result of that PI if that loss actually was incurred because of the fact that the alleged infringer did not act as would generally be expected, did not act as a bonus pater familias in the circumstances in question. For instance, he did not clear the way, or he did not await the outcome of nullity proceedings after these were pending. And this applies provided that, so there's a second condition, that's why I also say it's weighing the bonus pater familias assessment in respect of both parties, because it also applies provided that the IP holder has acted as would generally be expected in those circumstances. So briefly put, if the IP holder acted diligently and the alleged infringer did not, and not acting diligently is, for instance, and that's what we understand, not clearing the way or awaiting the outcome of the nullity proceedings, then afterwards the defendant cannot ask for damages based on or resulting from the PI. There have been two questions in from the Hungarian court. The first one is this, and let's summarize it on the next slide. Does Article 9.7 of the Enforcement Directive oblige the member states to establish substantive rules of law on the liability of parties and the amount of method of compensation to apply Article 9.7 of the Enforcement Directive? That question is linked to the second question, or at least both questions have been dealt with together by the CGU. And the second question is then summarized on this slide. Does Article 9.7 preclude national legislation, by virtue of which those rules are the general rules on civil liability and compensation, which take into account whether or not the alleged infringer and patentee acted as bonus pater familias in the relevant circumstances? The CGU reformulated both questions into one question, and it's, I would say, a bit more tied to the second question, actually. And it asked, does Article 9.7 preclude national legislation? And this is the legislation which was applicable in Hungary, which provides that a party shall not be compensated for losses which he has suffered due to his not having acted as may generally be expected as a bonus pater familias in order to avoid or mitigate his loss, even though the patent, and this is the particular circumstance, even though the patent has subsequently been found invalid. And the decision of the CGU is pretty clear. The answer is no. Article 9.7 does not preclude that type of national legislation. In other words, national legislation may provide that a party shall not be compensated for losses due to his not having acted as bonus pater familias, as may generally be expected, even though the patent has subsequently been found invalid. And then there's the important addition, to the extent that, provided that legislation, that national legislation, also permits the court to take due account of all the objective circumstances of the case. And one of these objective circumstances is the conduct of the parties, and particularly the question whether or not the applicant, the IP holder, has abused or not abused those measures. If a court cannot take into account, in other words, whether or not the patentee has abused the measures and just precludes any type of compensation if the defendant has not acted diligently, that, for instance, would not be in compliance with the Enforcement Directive. But if also the patentee's conduct can be taken into account, the provision, the national provision, is entirely compliant with the Enforcement Directive. It's, let's say, a rather specific conclusion in relation to the Hungarian law. It's really focused on what was actually the rule in Hungarian law, with that additional, like I said, provision that you need to take into account all the objective circumstances of the case, that the national courts need to be able to do so. But that decision is based on a number of general ideas, and the motivation in the Bayer decision is, in our view, essential to understand it, because actually in the motivation in the Bayer decision, the CGU takes a position on a number of issues that are actually very relevant in this regard. First of all, the Bayer decision states that the concept in Article 9.7 and also in Article 7.4 of appropriate compensation must be given an independent and uniform interpretation, meaning it needs to be applied uniformly throughout the European Union. It's not, and this actually answers the first question of the Hungarian court, it's not something that the method and the meaning and the scope cannot be determined nationally, because there's no express reference in Article 9.7 to national law being able to do so. And also recital 7 and 8, as well as 10, recital 10 referring to the high, equivalent and homogeneous level of protection, recital 7 avoiding major disparities and also referring to the major disparities that existed between member states prior to the enforcement directive, and recital 8, the fact that these types of disparities affect the proper functioning of this tool of IP rights and affect equivalent protection throughout all the member states. In view of this, appropriate compensation needs to be applied uniformly and independently, and that needs to be based on the context of the provision, Article 9.7 in this particular case, and the objective of the enforcement directive, as we will see in the next slides. An additional point that the CGU touched upon is the fact that it needs to be an independent and uniform interpretation, and the conclusions that it will actually lead to under such independent and uniform interpretation. Well, these conclusions are in line with Article 57 of the TRIPS agreement. As Article 9.7 is based on Article 57 of the TRIPS agreement, Article 9.7 of the enforcement directive. It needs to correspond, of course, because all the member states are all members to the TRIPS agreement, needs to correspond with Article 57. Now, that's not an issue according to the CGU, because the preamble of TRIPS refers to the fact that it aims to ensure effective and adequate IP protection. And Article 1.1 also states that members are entitled to implement more extensive IP protection than is required under the TRIPS agreement, so minimum harmonization. The EU's choice under the enforcement directive is, according to the court, in line with TRIPS. It also aims to ensure high, equivalent and homogeneous level of IP protection. That doesn't mean, of course, that the national courts don't have any discretion. There are two things here that are important. The fact that the conditions under Article 9.7, the revocation of the measures, the provisional measures in this particular case, the lapsing of these measures, or the later non-infringement or finding of non-infringement or invalidation of the patent in proceedings on the merits. Well, the fact that those conditions are satisfied does not mean that the national court automatically and in any event needs to provide compensation to the defendant. This actually also already shows in our view that there is no, and paragraph 64 will also discuss that, we'll see that in the later slide, but this already shows that strict liability as such is not possible, in our view at least, according to the CGU, or that Article 9.7 cannot be interpreted as imposing a system of strict liability. What the national courts need to assess is whether the compensation is appropriate, and whether it is appropriate to order a compensation, which should then also be appropriate. And here it already makes an important remark, and we'll see what that is based on. Appropriate means that it is justified in the light of those circumstances. And the term justified is something that we'll see pop up in the subsequent paragraphs, referring back to recital 22 of the enforcement directive. And in recital 22, the fact that the provisional measures need to provide, that there need to be guarantees provided, needed to cover the costs and the injury caused by unjustified requests. So recital 22 refers to unjustified requests, and defendants need to be able to recoup any injuries for or based on unjustified requests. So whether it's unjustified or justified is essential based on recital 22. Recital 22 also states that provisional measures are justified when any delay would cause irreparable harm to the IP holder. On the other hand, as the court discusses in paragraph 62, provisional measures are unjustified if there is no risk that irreparable harm may be caused to the IP holder in the event of delay in the adoption of the measures sought by him. And then that last part, the question I think you could then ask, and I think many of the referring courts also struggle with. The fact that defendants market their products even though a patent application has been submitted or there is a patent hindering marketing, is that something they can do, or is that actually, well, they can of course do, but is that actually objectively indicative of the existence of a risk of repairable harm? And that is what the court says. So actually what it states here also is, if the defendants, for instance, a generic company markets the products even though a patent application has been submitted or a patent has been granted hindering such marketing of these products, then that particular fact in itself is objectively indicative of the existence of a risk of irreparable harm, which justifies granting these provisional measures. So then the next question, and I think that's the essential question in this particular case, in CGU buyer's case, but also in the case that we will discuss of the Brussels Court of Appeal, is whether or not the invalidation of the patent in itself will then lead to a conclusion that it was unjustified. Again, the Court of Justice says no. The mere invalidation of the patent later on does not mean that there needs to be compensation, or is not in itself decisive in proving the unjustified nature of the PI application. What the courts need to look at, as we will see on the next slide, is how and whether or not there has been abuse. And why is this, according to the CGU? Because a different conclusion, saying that the mere invalidation of this patent would lead to strict liability and would lead to liability, such conclusion would run counter to the objective of ensuring a high level of protection of intellectual property. It would discourage the patentees or IP holders in general from availing themselves to the measures referred to in Article 9. And then the question is, invalidation as such is not sufficient. What needs to be proven? And I think in paragraph 66 to 70, the CGU makes clear that there needs to be, and it refers in this case, we already referred to recital 22, here it refers to Article 3. The CGU makes clear that there needs to be some kind of abuse being demonstrated. And that's the basis for that abuse is found in Article 3.2, where it's stated that these measures are to be applied in such a manner as to provide safeguards against their abuse. So the member states need to offer guarantees that the measures are not abused, and in other words, they need to determine, when assessing whether there needs to be compensation, they need to determine whether the applicant, the IP holder, has abused or not abused the measures, provisional measures, taking into account all the objective circumstances of the case, all the objective circumstances, including the conduct of both parties in that particular case. So that's buyer in a bit detail, I must admit, but I think it's relevant to also understand why and how the Brussels Court of Appeal then came to its decision of 11 October 2022. And this case, as I said before, as Christoph also addressed already, referred to a patent, an IP right, which was later found invalid after provisional measures had been imposed. Pretty similar in that regard to the CGU's decision in Bayer, but this case relating to the Belgian provisions. And the court immediately says there's no objective liability in such case. It needs to be assessed based on the general rules of fault liability. Why? Well, again, we cannot discourage IP holders from using provisional measures, first of all. Secondly, any other conclusion would run counter to the enforcement directive's objective. So essential is whether the IP right holder abused these measures, and that's something we need to be able to assess, the Court of Appeal also admits. And we need to be able to take into account the objective circumstances of the case. That's what Bayer said. Well, there's no issue under Belgian law because Article 1382 of the old Civil Code, to which Christoph already referred at the start of this presentation, allows precisely to do that. So Belgian law is in compliance with the directive. The next question was then, in this particular case, did the patentee, Novartis, commit a fault by enforcing the provisional injunction, the PI, based on the later revoked patent? Well, first of all, the court says Novartis was granted a PI by the Brussels Court of Appeal, and that PI was actually challenged before the Supreme Court and was confirmed by the Supreme Court. So there's in any event a clear decision. Secondly, the fact that the patent is deemed not to have existed because of this invalidation and the retroactive effect is not sufficient to say that Novartis committed a fault. Otherwise, that would be just the same as accepting strict liability, because any patent, when invalidated, would have retroactive, or the invalidation would have retroactive effect. And finally, and this is for the court clearly the benchmark rule, has the patentee, did the patentee know or should have known that this patent was invalid? That's actually what needs to be looked at. And the defendant, Mylan, in this case, does not sufficiently prove that. So importantly, also the burden of proof is, of course, on the defendant. So Mylan does not prove that Novartis knew or should have known that the patent was invalid. First of all, yes, there were two negative decisions, one by the UK Court of Appeal, one by the first instance court in the Netherlands, one by the opposition division in first instance, but they were all based on different grounds and motivation for invalidity. Secondly, the Madrid court later declared the patent valid. So it's not that it was a clear-cut case, which could lead to a different conclusion or knew or should have known that the patent was invalid. But in this case, it was for the court sufficiently clear that Novartis did not know or should not have known. And also, of course, there's the legal principle that appeal was pending before the TBA and that this had suspensive effect on the opposition division's decision. The fact that Novartis had submitted auxiliary requests also did not affect the conclusion of the fact that Novartis did not commit a fault. Why? Also because Mylan's product remained covered, and additionally because Novartis also asked the patent to be maintained in subsidiary order as granted. Finally, statistics to which Mylan had referred regarding the chances of success before the TBA, and the argument was, of course, well, look, the chances are really low that the TBA would declare an invalidated patent by the opposition division subsequently valid. As a result, Novartis should have known this. That also is not sufficient. Every case needs to be looked at on the basis of the own and specific facts. Finally, additional assessment by the court. Whether or not that's necessary, I think it's also already part of the first assessment, but in any event, Novartis did also not abuse its right, a very particular standard of abuse. They did not manifestly exceed the normal exercise of their patent by a prudent and foresighted person. Again, it was granted by the Brussels Court of Appeal, and the Brussels Court of Appeal at that point in time balanced the parties' interests. Last point that Mylan attempted was restitution based on enrichment without cause. I'll spare you the details of the underlying conditions, but one of the conditions is, of course, that there can be no cause for the enrichment, and in that case, and the transfer of value from one party to another without a cause. Only if there's no cause, you can ask for restitution. But here the Court of Appeal, I think, rightfully so, accepted that there was a cause. Actually, what was the cause? It was the PI that was granted by the Court of Appeal itself. And the later revocation as such does not mean that all of a sudden there was never a cause. Again, this would be the same as accepting strict liability. Last question that I will discuss, looking also at the time, is what is the application of Bayer? And that's not part of the Brussels Court of Appeal decision, but what is the application of Bayer if the measures are revoked in third-party opposition proceedings or an appeal, and not if the patent has been invalidated at the later stage in proceedings on the merits? Well, as Christophe already explained, there is presently Belgian case law which actually comes to a rather unanimous acceptance of objective liability in such cases. And the basis is Article 1398 Judicial Code. But I think if we look at the Enforcement Directive, the wording itself of the Enforcement Directive already shows that these provisions also apply if the measures are revoked in third-party opposition proceedings or appeal. And it states where the provisional measures or measures to preserve evidence are revoked. Secondly, in the CGU judgment in Bayer, there's no distinction between whether the patent is invalidated. Yes, it concerns also the question what happens if it's invalidated. But as I explained before already, there was also an overturning appeal of the first instance PI. I'm not sure whether the court actually wanted to ask this. It didn't. It referred to the provision on the invalidated patent. But in any event, in its motivation, Bayer, the CGU and Bayer, never makes a distinction between the first part where the provisional measures are revoked and the second or the third condition or the third situation where the patent is later invalidated. It says that the fact that the provisional measures have been repealed may constitute one of the conditions for the application of Article 9.7, but is not in itself a decisive factor in also proving that it is unjustified. So again, you could come to the conclusion that also in case of a revocation in PI decisions, the first instance PI decision is revoked by the Court of Appeal, you may need to look at whether or not the enforcement of the first instance decision was unjustified or not. So the question, I think, and this will definitely be a question which will be raised before the Belgian courts, we would expect is, does the general rule of Article 3098 of Article 3098 of the Judicial Code, does that apply for provisional enforcement of IP rights, for provisional enforcement of PIs based on IP rights or not? And that leaves me the pleasure of thanking you for this session and referring back to Christoph.
Yes, so that brings us to the present time. We have the Bayer decision. It's clear that the question arises whether you could make divergent decisions in respect of the three possible situations which are envisaged by Article 9.7 of the directive, and it's apparent that that should not be the case, that the legal conditions should be the same. The question is, of course, looking ahead, whether in particular within this context, wait a moment, that is, whether in particular within this context, the regimes of strict liability which are prevalent in a number of EU member states can remain in place. And that is in particular the question raised in the Mylan versus Gillett case, where the Finnish judge has put a number of questions to the Court of Justice again on the application of Article 9.7 of the Enforcement Directive. Just for your information, the factual background of that case, so it concerns the SPC for the combination product of tenofovir disoproxil and emtricitabine, the same SPC which led to the Teva decision of the Court of Justice on combination SPCs. And we are in a situation where in Finland the PI had been granted, subsequently revoked, followed by an invalidation of the SPC by a later decision of the competent court. So we are actually in a situation of a combination of the two situations. On the one hand, the provisional measures have been revoked. On the other hand, the judge on the merits subsequently has come to the conclusion that the title is invalid. And as I mentioned, also in Finland, is what we understand from the description in the overview, which you can find on the website of the Court of Justice. There is a regime of strict liability, albeit that it can be mitigated, taking into account the acts or the omissions or the conduct of the defending party. But the principle is strict liability. Obviously, the Finnish court had read the Bayer decision, and in particular also the paragraphs which Kirjan described to you, understood that the question of strict liability would come under question. That was also, I understand, the position of the SPC holder in the Finnish litigation. but noted, on the other hand, that this viewpoint was not shared by all courts, and our attention has been drawn to a recent decision of September 22 of the Landgericht Düsseldorf in respect of the Copaxone product of Teva, platinamide acetate, where the German court also applied strict liability, ordered the patentee to pay 5 million euro in compensation for lost profits to the alleged infringer, and considered that this was not prevented by the Bayer decision of the Court of Justice, and that also in view of the Finnish referral, there was no need to refer the question to the Court of Justice in view of the fact that the German court, under the applicable rules in Germany, while applying a regime of strict liability, is entitled to mitigate the compensation granted to the alleged infringer in such case, and that was deemed sufficient. The Finnish court clearly was more cautious and put the question to the Court of Justice, and it is clear that the Finnish court is somewhat reluctant to abandon the existing Finnish regime, but the first question raised, of course, is can the regime of strict liability under Article 9.7, but the same goes for Article 7.4 of the Enforcement Directive, can a regime of strict liability be maintained in view of the Enforcement Directive? And if not, okay, what then is the regime of the liability which should be applied by the national courts? Which circumstances must one take into account? And then the very relevant question, in view, of course, of the fact that a revocation of patent right is made ex tunc, so with retroactive effect, is it possible to base the assessment only on the circumstances prevailing at the time that the PI was obtained or was enforced? Or should one take into account the fact that the patent right has been found subsequently to be invalid ab initio? So what is the relevance of this circumstance? Obviously, we cannot prejudge on what the Court of Justice will decide, but it seems to us, as to the first question, that a strict liability regime is not possible unless the Court of Justice would, of course, consider that its previous decision in that respect cannot be maintained. So we would expect, but who are we, of course, but we would expect, in view of what has been stated in the Bayer decision, that the Court of Justice will reply negatively to the first question. Then arises the question, of course, what criteria should one apply? And as you heard from Kirian, I think that the Court of Justice already provided quite some elements to decide what is an unjustified application and what elements should be taken into consideration, in particular, in order to decide whether abuse is made of the procedure or not. And of course, it boils down to the definition of the legal concept, which should be uniform and applied generally all over the European Union, of appropriate compensation. It is clear from the Belgian case law that, I think that conclusion should remain or will remain, that a concept of fault liability, taking into account all circumstances of the case, including the conduct of the parties, is an appropriate way to fill in that concept. But of course, it is to be seen what the Court of Justice will decide. Will it indeed confirm the concept of bonus pater familias? Will allow me to use that non-gender neutral Napoleonic concept, but there are other ways to say it. Obviously, what would a normally reasonable, diligent person do in the same circumstances? And of course, if what has been done deviates from that standard, liability might arise. A question which would arise also within that context is, of course, to what extent can you take into account the conduct of the alleged infringer? Read the Bayer decision might remember that the Advocate General in that case clearly indicated that one could not request or expect the defendant, the alleged infringer, to clear the way. Although reading the Bayer decision, it is an element which could come into play at some point, in my view. So will that come up, and what weight will be given to that criterion is an open question. And then finally, there is, of course, the issue of the retroactivity of a revocation decision. Should we make a distinction on that basis with other situations? And reading the Bayer decision, as I mentioned, it is apparent that such distinction should not be made. If one applies the principles of tort liability, and that is exactly what the Brussels Court of Appeal did in the Bayer case, if one applies these principles, one must place oneself at the time when the alleged tort was committed. You cannot take into account subsequent events in order to assess the liability of a party doing or not doing something at a certain time. If not, otherwise you would indeed, through the back door, reintroduce the concept of strict liability. So it would seem that indeed, in respect of that point, we would expect, if the Bayer decision is to be followed, that indeed the retroactive revocation should not create a situation separate from the other situations envisaged by the legislator in Article 9.7 of the Enforcement Directive. And of course, as already mentioned, this case law at some point undoubtedly will also have an impact on the application of Article 1398 of the Judicial Code, the regime of strict liability, which under general rules is in place, but would not seem to be defensible anymore, one can say, in view of the principles set out in the Bayer judgment. But also the provisions on the application of the provisions in the patent law on the application of final judgments might indeed also be questions from that point of view, whether or not indeed, if you have a final judgment which has been executed, whether you can indeed keep the advantages you have obtained in view of the regime, the liability regime set out under Article 9.7 Directive as interpreted by the Court of Justice. So we have still a number of open questions which hopefully will be answered by the Court of Justice, but that, of course, remains to be seen. This brings our presentation to an end, but we still have 5 minutes to answer any questions which you might have, and unless I'm mistaken, there has been some question.
Yeah, I've looked into the questions, Christoph, while you were still giving your presentation. So I'll start with the first question, and please feel free to supplement. Of course, the first question is, if I can summarize it, does the defendant and the one claiming damages have 5 years to initiate legal action? I understand the question to refer to the statute of limitations, and for tort liability, which would generally be this type of liability, and the liability resulting from the enforcement of provisional measures, you have the distinction between you need to file your action 5 years or within 5 years indeed after you know the damage and after you also know the party that would potentially be liable, or in any event 20 years after. Now in this case, of course, since you're in these proceedings, in these PI proceedings, you know the party, and I think as soon as, that would be our view, I think, as soon as you know the provisional injunction that it has stopped, and so you know your damage, so when it is overturned or the patent is revoked, in that case, or starting from that date, you would have, in my view, 5 years to file your damages claim.
I agree that it would be the regime of tort liability and the prescription rules applicable to tort liability.
You could have contractual issues relating to licenses, but that was definitely not the scope of this presentation, where the statute of limitation would be 10 years.
That is an other kind of worms, I fear.
Yeah. The second question is, so under the UPC, briefly put, do you think that could change things? Would it lead to a more uniform application of these rules? And could it lead to, if I understand the question correctly, different rules as well? Well, I think, first of all, of course, the UPC will still need to comply and apply the enforcement directive, comply with the enforcement directive. So also the rules under the UPCA, under the UPC agreement, need to be applied in compliance with the enforcement directive. And in that regard, the Court of Justice will still have the final word. So I think the Court of Justice will definitely determine whether or not it's strict or fault liability. And I would personally not expect this to change drastically.
It is obvious that the UPC will have to apply what the Court of Justice decides in respect of the enforcement directive. There is no discussion possible.
And then the last question, at least on my screen, but there may have been additional questions in the meanwhile. Third parties who, for instance, NHS or other sick fund providers who would also claim damages or could claim damages, would the same rules apply? Well, basically, first of all, in Belgium, that's not something that occurs frequently. In our view, and to my knowledge at least, that has not been done in the past, but you can never exclude it, of course. Now, if they would apply for damages, I think indeed the same principles would apply. The question will be whether or not the patentee or the IP right holder is liable for the damage caused in that regard to, for instance, the sickness fund provider. In Belgium, the INAMI, the NIDI, and it would be the same question whether or not the patentee knew or should have known that the patent would be declared invalid.
Indeed, certainly in Belgium, until the Court of Justice would decide otherwise, or I'll never know, of course, the Belgian Supreme Court would at some point take a different stance, which is not for immediately in any instance. Tort liability will apply, and that applies generally, of course, to the parties, but also to third parties, but they would have to start proceedings and obviously claim damages or join the present proceedings. Why not? That is possible. You cannot exclude it. If there are no further questions, I think we will close this session just in time. We enjoyed it, and we hope that you enjoyed it too. And obviously, this is an interesting issue. The last word has not yet been said, and perhaps we will have the occasion to organize a new IP update once the decision of the Court of Justice in the Gilead referral is known. in any instance, thank you very much and hope to see you later.